Welcome to Case by Case. This is a podcast brought to you by Floyd Zatkovich. This is Calum Jane. I'm Luke Zatkovich.
Every episode, we read a case independently of each other. To jump on the podcast, we hit record. So what you get is our raw thoughts on that law.
And we're super excited with some of the guests we've got coming up on future episodes. So keep an eye out.
And if you like the podcast, all we'd ask is that you hit subscribe and share with your network. Okay, let's get into it.
Let's do it.
Welcome to Case by Case. This is a podcast brought to you by Calum Jane and Luke Zatkovich. I'm Luke. Calum, how are you?
I'm very good, Luke. How are you doing?
Yeah, I'm well. Looking forward to today. This is going to be good. We're delighted to be joined by, I'm not sure if we can say regular yet, but definitely returning guest, Alexander Wright KC of Four Pump Court. Alex, how are you?
Well, thank you, Luke. It's a pleasure to be back. It's great to be on this one.
I'm more outgunned than normal on this one because this is a case where Luke was running the case and Alex was arguing the case. So compared to the knowledge you guys have of this judgment, I'm far behind. But I'm actually looking forward to being a semi listener to the podcast today and listening to you guys talk about something you really know about.
Yeah, it's funny, Calum, because in a way, I've got to make sure that I just stick to the script, as in what's written in this judgment. And I'm going very careful, as will Alex, on only talking about what's written down in this public judgment. We're obviously not going to talk about anything in the wider context or anything behind the scenes, so to speak. So in some ways, you are as well armed for this discussion as the two of us are.
Yeah, and it's difficult. We have to be careful because as the judgment says in paragraph 6, there's a long and inglorious history of procedural difficulty which led to this trial being expedited. So we have to pick carefully the parts of that history that we discuss and the parts that we don't. And obviously, the parts that are in the judgment are public record. But you're right; you have to walk the tricky balance of knowing more about the case, I suppose, than can be set out in 20 pages of judgment. But it's a fascinating one, and this is all about Section 32 of the Arbitration Act, and I've never had a decision on Section 32 of the Arbitration Act, so it's a really interesting one to read through and to see, and I'm looking forward to discussing it with both of you.
It's an interesting section. It's much rarer used than perhaps it should. I've actually had a previous Section 32 a few years ago. But I've spoken to a number of people who are surprised it isn't used more often because, as you know, normally where there's a jurisdictional issue, you have the whole hearing before the tribunal, and then you have to potentially do it all again under Section 67. So it will be interesting to see if more Section 32 judgments come out. But I think it's something that should be used more.
Yeah, because that was actually a big talking point when they were going through the consultation around updating the Arbitration Act, was this issue where if you have a jurisdictional dispute, then the way through it is effectively to go to the tribunal to get your award on jurisdiction. Then whoever doesn't like it can challenge it in the courts under Section 67. And because it's a question of jurisdiction, you basically have to restart from the ground up and rehear the jurisdictional objection from scratch. And we've had cases before where the jurisdictional objection is the whole case. For example, the spate of subjects cases that there were over the last few years, where we had a few of those as well when they were all the rage. And the question is, has the Arbitration Act been agreed from a jurisdictional perspective? But it's the very same question as, has the contract been agreed? So you're effectively relitigating the same point twice. And Section 32 seems to cut through that quite neatly. May be helpful if we turn to Section 32 for everybody else and talk through a little bit of what it actually does, how it actually works.
Yeah, I think that's a good idea. And while you're just pulling it up, Calum, one of the, I suppose, complexities to using Section 32 is one of timing, right? And in this particular case, as noted in the decision, there were good reasons for expedition because the appointment of the arbitrator, it then determined who was going to sit on this panel, and then the panel was then going to decide whether two opposing purchase options, which one of those was the valid one. And that all had to be resolved by, around July this year because those purchase options were going to lapse. And so, the parties, and there wasn't contention over this. There was agreement over this that the matter should be expedited, and we'll talk about the shape of that in a moment. But for a lot of cases, there may not be that same degree of expedition in the case. And then, so if you're going off under Section 32 into court, there can be significant delays. But that said, I'm with you, Alex. It's something I haven't seen used before. It wouldn't surprise me if it's used more regularly down the track. And this is a great example of how it can be used. It's quite a complicated case in many ways, and there are a number of layers to the onion to kind of unpeel, but that we will. Have you pulled it up now, Calum?
I've got perfect purchasing of time there for me. Like, I've got it on screen in front of me. And I think the first point I would say is, if we look at Section 32, we have a 32.1 says the court may, on the application of a party to arbitral proceedings, upon notice to the other parties, determine any question as to the substantive jurisdiction of the tribunal. And there is the loss of right to object is noted there too. But the first point there is that this is something which is open to a party to apply for. And Section 32.2 kind of limits it. It says an application under the section shall not be considered unless it is made with the agreement in writing of all the parties to the proceedings, or it is made with the permission of the tribunal. But there you do have this route to apply to the tribunal for permission, to obtain permission from the tribunal as one party, I guess, to obtain a contested permission where the other side says we don't want to go for a Section 32, obtain that permission from the tribunal, and then apply to the court under Section 32.1. So it is something that you can use unilaterally. I don't know, Alex, in your previous example or examples you've seen this used, because obviously the one that we're discussing today, I think was by consent that the parties use Section 32.
So the previous case that I was personally involved in was one where we did apply to the tribunal. And I think, although there's not a huge number of Section 32 decisions, there have been others where the tribunal's permission has been sought, and then you've gone under Section 32.2b. Obviously, the big difference between that and where you have the parties' consent is that if you're applying to the tribunal, you then have to satisfy the further conditions in terms of producing substantial savings in cost, the application being made without delay, and rather more nebulously, there is a good reason why the matter should be decided by the court, which is obviously quite a broad discretionary factor. And as I say, there isn't a huge amount of jurisprudence on that. But here, as you say, it was by consent, but this is precisely the sort of case where actually it makes perfect sense for Section 32 to be used and to get a final ruling on jurisdiction straight away. The other thing about Section 32 is, we may come on to it, it's difficult to get onward permission to appeal to the Court of Appeal, and indeed Judge Padding refused permission to go to the Court of Appeal to the unsuccessful parties here. So you really do get the single decision, and that's it.
Why is that? Is that a timing issue where they just appreciate that you need a decision quickly, or is it is there some other reason why these are difficult to appeal?
It ties into a lot of the filters under the Arbitration Act claims. So it's similar wording to, for example, Section 69, where you need the permission of the commercial court to go to the Court of Appeal. You have that same wording in Section 32.6 here. Effectively, you need to persuade the judge that there's a point of law of general public importance. And here, Judge Padding decided that there was no English law issue of general public importance that would justify going up to the Court of Appeal.
Okay, which does give you the certainty,
Right. So yeah, and so before we get more into it, let me just get the case name out. We are talking about the decision of His Honour Justice Calum KC, who was sitting as a judge of the High Court in the case of Eletson Gas LLC and various defendants, A Limited through. The neutral citation number for this matter is 2025 EWHC 1855 Comm. So we're talking about a commercial court decision, and it was handed down on the 14th of July 2025. So not that long ago. And as we're going to explain, there are a number of layers to this, and we've talked about Section 32 and how it's not been used all that often, but the substance of the dispute, I think, also raises a number of areas that haven't been traversed that much either, in terms of recognition of arbitral awards and the status of an award. In this case, it was a New York arbitration award that subject to pending confirmation / vacator proceedings, and how a foreign court, in this case the English court, should be treating that award in the interim, whether it has effect, what's its status, and then various other related issues like issue estoppel and what have you. So we're going to get into those in detail, but I think it's fair to say that this is an important decision that traverses some of those cases which aren't dealt with in a huge amount of other authorities, Alex.
I agree. And what was interesting was the interaction between some of the English law issues in relation to, for example, Section 101 of the Arbitration Act and questions of issue estoppel, and then feeding into that, there were a range of different foreign laws, particularly, for example, US federal arbitration law, this being a New York seated award, and how the judge approached those two different systems of law and how they fit together in terms of recognition under, for domestic purposes, the Act, but ultimately with the New York Convention sitting behind that.
Because this is a question of jurisdiction, but is a question of jurisdiction that Judge Pelling is at pains to mention is almost one that he's has his hands tied from making. So he has to make it in the context of the English arbitration. But this was all playing out under a much broader background, which is happening across the pond in the US. And there's a real tension when you read this judgment with Judge Pelling on the one hand saying, I have to come to a determination for the purposes of this Section 32 application and the English law arbitrations, which the court has supervisory jurisdiction over. But at the same time, I can't in any way step on the toes of a separate set of pleadings, separate proceedings that are going on, which seem to mirror quite closely these proceedings in the US, where there's a different, well, maybe not different, but there's a decision to be made there, which is independent of this decision.
Yeah, and Judge Pelling, what one sees it from the judgment, paragraph 8, he was at pains to make clear that he was not getting into any contested findings of fact, because in New York there are various allegations of fraud which are used to impugn the award, but that was not something that the English court was getting into. It was approaching it solely as a matter of, first of all, English legal analysis, but also then having regard to the foreign law evidence that was put before the court as well. But this wasn't intended in any way to tie their hands in the New York courts. And
perhaps it's helpful to go into a bit of the background, maybe. Might flip the normal way of doing this and throw to Luke, who knows this background extremely well, to give a bit of background, at least to the English law issues that are here, with some of the wider context as reported in the judgment.
Yeah, well, I think the way to start the background is to look at it from the so-called innocent third parties perspective. And there was a lender here, anonymous for the purpose of this judgment, who had provided basically a lease bareboat structure here for these vessels. And the Eletson Group's interest in those three vessels was as charterers under bareboats, with a purchase option to buy those vessels by a certain date. And as I mentioned before, the end date on the time for exercising those purchase options wasn't exactly the same for each of them, but it was in July this year, thereabouts. And as this kind of dispute has developed between two sets of parties over who has control of the Eletson Group, and that's a big wider story, which, if anyone's interested, they can go find plenty of information about that online, which is played out in US bankruptcy proceedings and in the SDNY in respect of the award. A lot of that's published and plenty to say about that. But in essence, there's a wider dispute between our clients, who are the 4th to 8th defendants in this matter, who have, through the US bankruptcy, been installed as now the owners of the Eletson Group. And then, there's various kind of downstream disputes on that. So that's on one side of this overall dispute. Then on the other side are the former managers of this fleet of gas vessels and other tankers. So you have these 3 bareboats, which are the subject of this judgment, with a third party who's not involved in the underlying dispute. And then you have these 2 warring parties, so to speak, our clients and the former managers, who are both saying that they still control various Eletson entities. And in respect of these 3 bareboat charters, the Eletson entity, Eletson Gas, is the charters under those bareboats. And so you have the former managers and our clients who are both saying that they still control Eletson Gas. Essentially, that's what is happening here. And so both sides have issued purchase option notices under the bareboats to this third-party lender, saying, we're in control, we want to buy the ship, here's our notice, we intend to complete by the end of July. The lender, receiving these 2 conflicting notices by different parties purporting to act on behalf of Eletson Gas, has said, well, which one do I accept? I don't know who to accept. The way that they thought to resolve that was to commence arbitration, appointed an arbitrator under the bareboat charters, arbitration agreements being in those bareboat charters, London arbitration, English law contracts, and put it on Eletson Gas, the charterer, to then respond. And so both sides then issued, both appointed, purported to appoint an arbitrator on behalf of the directors that they say should be installed for Eletson Gas. And you then had 2 arbitrators appointed. The former managers had appointed theirs, and we had appointed ours on behalf of the 4th to the 8th defendants in these proceedings. So clearly you have a problem as to the constitution of the tribunal. You have an arbitrator appointed by the lenders on one hand, and then 2 different parties saying that they act for the counterparty, each purporting to appoint an arbitrator as the second appointed arbitrator. The parties then agreed under Section 32, as Calum explained, there's 2 ways to then take that preliminary issue as to jurisdiction off to the court, the English court, in its supervisory capacity. That is by consent or by one party asking the tribunal for permission. In this case, the parties consented to that matter going off to the English court for resolution. And then there was, which we don't need to get into, but there was a number of procedural issues in getting from taking it into court and getting to a hearing on that matter. I think the headline point on that is that it was expedited, and the court, and this is worth, I think, putting an underline on, the court really did accommodate the parties and was sympathetic to the position of the third-party lender in, being in this situation where they're trying to complete on or deal with the counterparty to complete on these purchase options by the end of July, but not knowing which party to deal with. And that urgency was a sufficient reason for the court to expedite this matter over other matters. And of course, the parties are grateful to the court for doing so and prioritizing this dispute over other court users. But it is an example of when there is a significant prejudice that might be suffered, that the court will entertain requests for expedition. So we then end up in a contested hearing. The third party lender coming along for the ride, so to speak. It did make some helpful, what was it called? Framing kind of route to verdict, I think, as Judge Pelling refers to in this judgment. But really, they were on the sidelines, and this was a dispute between the two warring factions, each saying that as matters stand, and this is really important to emphasize, at the time of this judgment, that the fourth to eighth defendants, our clients, were either in control or the other party was in control. And that's important because the court in this decision was not being asked to resolve the final decision as to who was in control of the company forevermore. They were being asked to look at it at a point in time, this point in time, as at the time of the judgment, who was in control of Eletson Gas and able to properly appoint an arbitrator on these bareboat charters. So that's the background. There's a lot more that can be said, but any other kind of points, Alex, you want to build out?
No, I think that's a very pithy summary of quite a, as Judge Pelling called it, long and inglorious history. But you're right to say it came to the court in a slightly curious way. But it's interesting, I suppose, that the jurisdictional dispute was in a way something that was forced by the parties, because of this quirk that both sets of competing directors purported to appoint a different arbitrator on behalf of the claimant company Eletson Gas, and it's only by reason of that procedural odyssey that actually cloaked the English court with jurisdiction under Section 32. So it was degree of creativity there that would allow this matter to be brought before the court, because ultimately it's a shareholder dispute where the underlying substance of the final decision is going to be determined elsewhere, but it simply came to the English court on the basis of this procedural vehicle.
And the expedition in this
and then,
case is slightly different.
sorry, Cal, you go.
Sorry, I was saying the expedition in this case is slightly different to some of the urgent cases that we and a lot of our listeners will be used to. So, for example, if you need an injunction to stop somebody doing something immediately, then usually you need the injunction a week ago. And it's a case of how quickly can we prepare the papers, and then how soon can the court possibly accommodate us. And there you're really looking at an urgent hearing, or the court to make available time on an urgent basis. Whereas this is slightly different. This was, I recall the team working very, very hard on this against a very compressed time frame. But it wasn't a situation where it was one of those, we need to be in court in 3 days' time. I think there was a couple of months, maybe 3 months or so, of lead time. So what you're doing there is bringing forward the court dates for, as you said, Luke, is more expedited than a normal hearing would be. But at the same time, there were still a lot of the ordinary procedure that you'd see in terms of the exchange of documents, just to a much more compressed time frame. And I think the availability for the English court to provide that, where there's very good cause, is something which is worth bearing in mind, because we've seen something similar earlier in the year where we had an issue that really had to be resolved, and this was outside of court, where the timelines it was in arbitration, where timelines are obviously much more at the parties and arbitrators' convenience. But again, in arbitration, you would often have a fairly standard procedural timetable, which can be deviated from, but is usually the same, whether it's under the LCIA or the LMAA or anywhere else. You have your time frame, which is normally followed. And in that case, it was in both parties' interest again to expedite something to get a decision before a certain date, at which point it would have been too late. So it's worth thinking about, I guess, for practitioners listening in. Is expedition something, whether it's court or arbitration, is expedition something which is helpful to you to get a decision before you end up blowing up the whole case? I suppose if there hadn't been an expedition here, then the loss could have been really, really significant.
Yes, I agree. And actually, both commercial court and London arbitration are excellent in terms of, in an appropriate case, fashioning a an appropriate procedural timetable and expediting cases that warrant it.
Yeah. Which then, I suppose, brings us on to... Sorry, Alex.
Yeah, just to kind of set the scene a little bit further and kind of map out the issues for discussion today. I think it's also worth explaining that there's kind of two halves to the dispute, if you like, as to who's in control of Eletson Gas, as dealt with by this judgment, and that's the shareholding of Eletson Gas is comprised of preferred shares and common shares. I think there's one other very small shareholder, but for present purposes, a common shareholder and a preferred shareholder. The common shareholder issue, that all turns on the US bankruptcy and what's happened with Eletson Holdings, who are the common shareholders of Eletson Gas, and whether the US bankruptcy brought about a change in control. And Eletson Holdings at the time of the bankruptcy was a Liberian company. So you had evidence that was expert evidence that was led on US bankruptcy law and then Liberian law, looking at the effect that US bankruptcy had in Liberia. So you had kind of two layers of expertise that needed to be presented to the English court to deal with that side of the dispute. We'll get into the specifics of that in a moment. But that's kind of one half of this, and the much shorter part of this judgment. And Judge Pelling notes that he deals with that in a much kind of shorter passage in the judgment. The beef of it, or the big dispute here, was on the preferred shares side, and the preferred shares that is what is the subject of this New York award, James Award, that is currently subject to vacator proceedings, and the former managers are seeking to confirm that award, and that is still pending in the Southern District of New York. And the status of that award required evidence to be led on US arbitration law, and so you then have this layer of US arbitration law that was led before Judge Pelling. And Eletson Gas is a Marshall Islands company itself. So, whilst this has been presented to an English court under an English law contract, the English court is actually being asked to look at this whole thing through the prism of Marshall Islands law. And so you've then got Marshall Islands law as another layer, looking at, well, how does the US arbitration law play out in the Marshall Islands context? So you actually have four sets of foreign law being put before the court here, with, at least on our side, we put forward four experts. And that probably explains some of the scurrying around you're talking about, Calum, in getting all together within 2 or 3 months for a 3-day hearing. So, yeah, but you've got these two sides to the dispute. So maybe we should get into the Eletson Holdings, the common shareholder side first, Alex, and just kind of tuck that one away and talk about what was going on there.
Yes. Just to unpack that further, there was an important distinction between the ownership of the shares as such and control of the shareholders. So on the preferred shares, the question was whether or not those shares had in fact been transferred, and we'll come on to that. On the common shares issue, there was no question that the shares in Eletson Gas were held and had always been held by Eletson Holdings. So the question was which individuals effectively had control over Eletson Holdings as the corporate entity. And that turned, as Luke said, on two issues, really. The first was the effect of the US bankruptcy. And then the second was the impact that had under Liberian company law, because at that time, Eletson Holdings was a Liberian company, and we had to adduce expert evidence on both of those, although as it turned out, the Liberian position wasn't particularly contentious.
Exactly. And yeah, so I think, looking at that and just kind of unpacking a bit, the English court was persuaded that the US bankruptcy decision had gone through and gone the way of the 4th to 8 repentance, in that the creditors, our clients, they were successful in having the creditors' plan approved by the bankruptcy court. And that was then confirmed in November 2024. And from that time, new ownership had been installed in Eletson Holdings as a matter of US bankruptcy law. Now, importantly, an appeal had been filed against the decision of the bankruptcy court to the Second Circuit in the US. However, the bankruptcy plan had not been stayed. And so because the plan had not been stayed, it came into effect, and indeed, those on the receiving end, the debtors, had to comply with it. And there have been a number of kind of follow-on consequences in the bankruptcy court for not implementing the plan. Again, that's for another time. But so far as the English court was concerned, the fact that the plan had not been stayed, and indeed, I don't think this was truly contentious, that the US bankruptcy had gone through, and the directors of the creditors had now been appointed for Eletson Holdings, and thus they then appointed through their directors into the directorship of Alexander Gas. The more, I'll say, contentious issue, although even that wasn't fully argued, in the sense that it was argued, but they didn't lead Liberian expert evidence, for example, on Liberian law. But the issue for decision, I suppose, was on the effect of the US bankruptcy under the laws of Liberia. And indeed, there had been applications brought, Alex, in Liberia, contesting whether the US bankruptcy was effective in Liberia.
Well, one thing which was interesting, and this was the subject of some of the Liberian law, was the authorities in Liberia itself, the deputy registrar, had acted upon the decision of the US courts. And one of the questions was effectively whether the registrar was entitled to do that without a formal application for recognition of the US bankruptcy, effectively whether they could do it by reference to the decision of a competent court of foreign jurisdiction as a matter of Liberian law. But that was something on which we had an excellent expert, a gentleman called Professor Banks, and he was able to explain why that was all in accordance with Liberian law. And one, as Luke says, there were unsuccessful challenges to the decision of the deputy registrar. So the Liberian law case was very strong by the time we got to trial.
So what were the key arguments that were put forward by the Kurtzikoff defendants? How were they framing their entitlement to, I suppose, their entitlement to appoint an arbitrator on behalf of Eletson Gas?
Well, the key focus ultimately, when it came to it, was on the preferred shares, which Luke has already introduced. And the issue there was effectively the effect of the JAMS award, and in a very simplistic level, one can understand why the Kurtzikoffs were developing the argument they were saying, well, we've got this award that finds that the preferred shares were transferred to our nominees, and that's effectively the end of the story. Actually, it's rather more complicated than that, both as a matter of English law, but also because of the impact of the challenges. The first point, and actually a threshold point, which they never really grappled with, by the Kurtzikoff parties, was the status of any New York Convention award in England has first to be recognised under Section 101 of the Arbitration Act. And in a way, the shortest answer to the issue of the preferred shares was simply that there had not been a recognition of that award in order for it to be accorded legal status in this jurisdiction. Now, although that in one sense might be regarded as a formal omission, in fact it's rather deeper than that, because of course if one applies for recognition, there are a series of statutory defences to an application for recognition, which again are derived from the New York Convention. And of course, what essentially was being sought to be done was to bypass those statutory defences by saying they can use the award without having to go through the procedural process of getting it recognised and therefore potentially engaging those defences. So there was a degree of an attempt to shortcut the act, and that is something that Judge Pelling said you can't do. So you have to get your award recognised first.
And could there have been a similarly expedited procedure through a recognition?
Potentially, yes. The difficulty here, of course, is because there were fraud challenges. What may well have happened, and there is a whole hierarchy of different arguments that were run as to why, even if putative recognition was relevant, why the court should not putatively recognise the award. One of them is that where there is a challenge in the curial court, so here in New York, to an award, the English court has effectively the power to stay recognition pending the outcome of that challenge. And one can understand why that is the case. If you've got heavily contested fraud allegations in New York, which was obviously the curial courts for the purposes of the New York City Jams Award, what would be most unsatisfactory is if you then had a parallel fraud challenge to the award in the context of recognition proceedings. So what you would expect to happen is if recognition proceedings were advanced in England, is for the English courts to say, well, what we're going to do is stay the award pending determination of the challenges in New York. And indeed, that was one of the arguments that we made down the hierarchy. But the absence of recognition was a threshold point. And the other point which we can touch on is that Judge Pelling was satisfied that, in fact, in any event, the award had been suspended by the curial courts in the US, both in terms of the sub-district, but also the US Bankruptcy Court, which was a competent authority for these purposes.
And can you so your ability to recognize the award is obviously difficult because the award has not been recognized. So that's the end of it. What about looking at other arguments along the kind of issue estoppel, res judicata, that kind of?
So I think that was the interesting question. So there was a potential debate as to whether or not you needed an award to be recognised in order for it to give rise to some sort of issue estoppel or abuse of process argument. And recognition as a standalone process is again quite unusual. Normally, when you're looking to recognise an award, you're then looking to enforce it. I mean, the classic case, you have an award saying you must pay X dollars. The award debtor has assets in England, so you're looking to take your foreign-seated award, get it recognised and enforced in order to then enforce against assets in the UK. Standalone recognition is much rarer, and even rarer, and indeed impossible it seems, is a situation where you have a kind of quasi-recognition. So you say, we're not going to formally recognise the award, but the English court should nonetheless give it effect for the purposes of, as you say, either issue estoppel or an abuse process. And what this judgment does, drawing on earlier decisions such as Miss Justice Tier in Svenska Petroleum, is say actually recognition is the process by which, even absent enforcement, a foreign-seated award is given legal effect in England. So that's why the absence of recognition was really a fatal hurdle for the Kertzkovs.
And intuitively, that has to be right, because Otherwise, you are de facto enforcing the award without going through the proper enforcement process.
Yes, and it was. I touched on Svenska. It was described. The recognition was described in Svenska as a gateway to issue estoppel, and that was also a formulation that Judge Pelling adopted in his judgment. And I think, as you say, that must be right. Otherwise, you can turn a flank to all of the protections that are in the New York Convention and then transposed into English law in the Arbitration Act.
Yeah, and I suppose that's the process of recognition in England.
Yeah,
is how the award has some standing in England. And throwing over to Luke.
Yeah, exactly. I completely agree with all of that. In many ways, Alex, I think one of the most important passages of this judgment is at paragraph 44 and 45, where Judge Pelling, had asked counsel for the Kurtzkopf parties, is their case only being put forward through the award? And there was a little, I think it's described essentially there as a bit of ducking and weaving on that. And question had to be put a number of times, and in a way, understandably so, because once it's clear that the way that they're presenting their whole case in this application is by reference to the award, then they're within a scheme, aren't they? They're within a scheme of how then does a foreign court look at this foreign award? How do you deal with it? And there's a whole convention on this, and that's been enacted into English law. And so to then say, well, we're going to kind of use it by reference, but then step around it on an issue estoppel basis, it always kind of struck us as kind of a difficult position to make out. But then there were, as Alex has flagged there at a high level, there are a number of arguments that we ran on this point to kind of hit it home. But at a fundamental level, as you say, if an English court wants to look at a foreign award and give it some type of recognition, even in a colloquial sense, it wants to look at that award and see what is decided, it has to do so through the prism of recognition.
Yeah.
And enforcement.
Can English court? Okay, so we're going to get to a position where we have these preference shares. There's the JAMS award that would help the Kurtzkopf parties, but they're unable to rely on it kind of as an award because they've not gone through the enforcement process. Does that not then mean you fall back just on answering the same question again, which is one of who has the better right to appoint an arbitrator? So it's not the case that the JAMS award cannot be enforced in England at this time, and therefore the Kurtzkopf parties' entitlement must be wrong. It's just a case of the JAMS award can't be enforced, therefore they can't rely on that as their reasoning for them being right.
So you fall back. So this is in a way why it was quite a hard-edged binary question about whether or not they can rely on the award or not. If they could, then they were going to say they're entitled to raise it as an issue of estoppel or abuse process. But if you have an unrecognized foreign seated award, then as the judge explained, you have then the old common law rule in Hollington and Hewthorne, on which the judge touches on at paragraph 48, and some of your listeners may be familiar, but that's a long-established principle of English common law, that where you have a decision made by another tribunal or court, then unless you can establish some sort of issue estoppel or other exception, then you can't actually rely upon those findings at all. They're not even admissible. So once the award couldn't be recognised or hadn't been recognised, and you therefore disposed of issue estoppel and abuse process, the entire award actually falls away. You don't have this sort of intermediate ground where the judge looks at it, weighs up the facts, and once the award is gone, then, as you say, the Kurtzkos was sort of pressed on this idea. Do you seek to establish some independent entitlement to the preferred shares absent the award? The ultimate answer to that was no. So once the award was gone, then any claim to preferred shares fell away, and they remained under the control of a company called Livono.
Okay, so their alleged entitlement to these preferred shares was purely a result of the JAMS award. They said that they have this. It wasn't a case of the JAMS award recognized an entitlement that they had, and they could run the same arguments to say they were entitled elsewhere. They needed the JAMS award because that was the document that gave them the entitlement. Do you see the distinction?
If you think about it from another way, Calum, if they had then started to argue the case on the merits, argue the facts of the case to say, well, these shares had actually transferred for XYZ reason, you then have a jurisdictional issue because that dispute is subject to arbitration, right? So you would then be in the position of saying, well, hang on, no, that issue has to go back to the tribunal. Indeed, there's an award on this that's subject to challenge. So you kind of end up back in the same place anyway.
Yeah. So why then not? I mean, was it a case that in reality seeking a recognition of this award in the English courts would have been difficult because you'd have, as you said, Alex, there you'd have to then start unraveling some of these frauds. Right? Yeah. So is it, if you're, and I know there's a lot more at play here, and there's obviously the fraud allegations are serious ones, and there's a US process that's going to have to continue in the US. If that was ultimately one where the Kurtzkopf parties were to win, then this would just be a case of bad timing. They weren't yet in a position to recognize an entitlement under the JAMS award in England when they needed to in order to exercise these purchase options.
So there are a number of, as Luke says, there are a number of layers to this. So you have the absence of recognition, but then even sitting below that, you have a number of reasons why there would not be recognition. So one of those was that the award had in fact been suspended for the purposes of the New York Convention and its domestic transposition under Section 103. And in fact, the judge accepted that it had been, if I can put it this way, doubly suspended. The first was by Judge Lyman, who was the judge in the SDNY, because he had granted effectively an anti-suit restraining enforcement of the award. But separate to that, there was an order made in the bankruptcy, which is referred to as the lift stay order, which again had the effect of suspending enforcement of the award, sufficient for the purposes of effectively depriving any entitlement to recognise. Clearly, if the SDNY proceedings go in favour of the Kurtzkopf, that is going to substantially improve their position, but you still have then the bankruptcy layer as well.
Yeah. So I suppose this isn't a cautionary tale of make sure you get your recognition done first before you try and use an award. This is more.
No, there were substantive reasons why the award, even if they had brought in an expedited application to recognise, I don't think it would have improved their position before the court,
because the recognition reward would have been beset by a number of difficulties around what's actually going on in the award process itself. And it's a fascinating case. I know it would be remiss not to say a big congratulations to you guys both for succeeding on it, and also to a large number of the Freud's Accurate team who, with a hearing like this with so many different points on foreign law, I know that it was extremely busy for the team for a number of months there, and no doubt for some of the juniors you're working with as well, Alex.
Well, it was a huge team effort actually to get something from pretty much a standing start through to a trial on an expedited basis with 4 different areas of foreign law expertise and some quite tricky questions of English law as well. It was brilliant actually for everyone to pull together and be able to get to this result.
Yeah, I echo all of that. It was a huge team effort, and well done to the team involved. And obviously have the UK team involved in getting this particular judgment, but there's also the US team that have been involved in this case in lots of other ways. So yeah, I'll leave it at that. But no, it's been a great team effort. I think also it's an unfolding picture. And I won't open up the discussion again, but there was an element to which particular court orders of US courts were being looked at in the context of other orders. And Judge Pelling says this with respect to the SDNY, is that there was the original order to suspend the award, but then there were developments after that as well, such as the injunction, which Alex has referred to, which gives context to what was meant by the original suspension order. So there was an unfolding picture as some of these arguments were being developed, which added another dynamic element to the way the matter unfolded. So yeah, great case. We're pleased to see the outcome. And yeah, thank you, Alex, for all your involvement in it, and to the juniors, Jonathan and Wei-Zhan, who are also involved. So yeah, any final thoughts?
Just that it was a pleasure to be involved in the case. It was a really fascinating one. So thank you for bringing me in.
That's great talking to you both about it. Interesting to get some more info on it and to hear it from the people who really know it.
Excellent. All right. Well, thank you for joining us today, Alex, and for your time. Good to catch up as always, Calum, and thank you for listening in, everyone. We hope you made something of this case, and that it's piqued some interest. There's a lot in it. It's a rare one. It's one that's not seen very often for many different reasons. And for those that love arbitration law in particular, I think there's a lot in this case to digest. And we've done wave tops in this talk, and I'd encourage you to have a good old read if you're interested in the topic some more. So thanks again, and speak soon.